Okay. Good morning, everyone. This is Panel A, open session meeting of the Medical Board of California. I'm Dr. Ron Lewis, and I'm the chair of Panel A, which this meeting is Panel A. We have a long agenda today. What I'd like to first do before we introduce ourselves is establish a quorum. So if we could have a roll call, please.
Dr. Hawkins?
Here.
Mr. Warmoth?
Here.
Ms. Wright? Here. Dr. Yip?
Here.
Ms. Sutton-Wills? Dr. Lewis?
Present.
We have a quorum.
Thank you very much. Very good. For the benefit of the court reporter, would you like us to either say our name, full names, or spell them, or do you have a list that you need? Oh, when you want to speak, you don't want us to introduce ourselves.
Well, yeah, we're not on the record. Okay. Actually, the first thing I'm going to do once we go on the record is have each panel member.
For him.
For
okay,
him.
we do it differently, so it's
Yeah,
all good.
Either way, it's fine.
It's all good. Okay. Okay, well, it's all good. And did you introduce yourself?
I have not. I am Administrative Law
There you go.
Judge Deborah Nye Perkins.
Welcome.
Thank you.
Okay. The first order of business of Panel A is the election of panel chair and vice chair. So we'll ask for nominations. Dr. Yip?
Nominate Dr. Ronald Lewis to the panel chair, please.
Okay, thank you. Any other nominations? I guess we'll just go ahead and vote on that nomination. Thank you. We'll just do a voice vote, or do we need to do it individual? We can see. Okay, so all those in favor, say aye.
Aye.
Opposed? Thank you very much for your confidence. Next time, someone else will get the opportunity. So, and then the next order of business is to elect the vice chair. So I'm asking, we'll go Dr. Yip and then Mr.
Mr. David Warmoth.
Okay. And David, did you put your hand back there? He's nominating Mr. Warmoth.
I was going to nominate Dr. Yips.
No, you take it.
Anybody else here? It's open. Okay, so we will have the vote by voice. All those in favor of Mr. Warmoth being vice chair signify by saying aye.
Aye.
Aye. All those opposed? Welcome, Mr. Warmoth, for willing to serve
Thank you.
your fellow Californians. Thank you. So we've done that. Next order of business is, and which I'm going to turn over to ALJ, is the oral argument on non-adopted a proposed decision for Alana Doreen Dixon. And with that, I'm going to turn it over to you.
Thank you. Are the parties here for Ms. Dixon's matter? If you'd like to come and take a seat at the council table, please. Is the Deputy Attorney General here for the Dixon matter? Oh, you're the Deputy Attorney General. Okay. Yeah, oh, there we go. We have a couple people here. All right. Okay. Court reporter's ready? All right. I will open the record on the oral argument in the matter of the statement of issues against Alana Doreen Dixon. This bears case number 8002017030778. It bears Office of Administrative Hearings number 20180905552. This matter is being heard before a quorum of the Medical Board of California, and I'd like the members of the panel to please introduce themselves for the court reporter.
David Warmoth.
Jamie Wright.
Dr. Andy Hawkins.
Okay, and I understand we have a quorum of the board here today. My name is Administrative Law Judge Deborah Nye Perkins. I'm an Administrative Law Judge with the Office of Administrative Hearings, and I've been assigned to sit with the panel, the board today, with regard to these oral arguments. Would the counsel for the parties please introduce themselves, beginning with the Deputy Attorney General?
Greg Chambers with the Attorney General's Office, representing the Medical Board of California today.
Alana Dixon, in propria persona.
Okay. And Ms. Dixon, you're here representing yourself, correct?
I am.
Okay. So let me give some information about how these proceedings will work. As you know, we're here for oral arguments. So the oral arguments are based only on the existing record. We're not allowing the introduction of any new evidence here today. The panel members may also, as well as the ALJ, may ask questions for clarification, but may not ask questions that would elicit any new evidence. Again, there's also a time limit set for the oral arguments. So how this will proceed is, Ms. Dixon, you will first have 15 minutes for your argument, and then after that, the Deputy Attorney General will have 15 minutes. Then you will have an additional 5 minutes to rebut, and then he has the final 5 minutes. And Ms. Dixon, I understand you're representing yourself here today. As such, my preference is to place you under oath, so that we'll do that before we actually get started, so that if you have anything in addition to say while you're arguing, it would be considered evidence. So could you please raise your right hand? Do you swear under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth in this hearing today?
Yes.
Okay. All right. So with that, I'm going to set my timer here so that we have the right amount of time for each person. So I'm going to set the timer for 15 minutes, and then if you'd like, I can give you a bit of a warning when there's 3 minutes left.
Is it possible for me to use my own timer here as well?
If you'd like, that's fine. But I'll keep the time for 15 minutes, and if you have your own timer, that's fine. And then when you're done, I'll hand it over to Mr. Chambers. Okay? Hold on just 1 second.
Then I had one procedural question.
Sure.
Is it possible for me to do the final rebuttal? I know that there's a procedure that's set forth in the statutes, but I was hoping that I might be able to get the last rebuttal.
Well, the procedure is set that it's 15 minutes, 5 and 5,
Sure,
so he gets the
absolutely.
last 5
Okay.
minutes. Okay?
Thank you.
All right. With that, Ms. Dixon, would you like to begin?
Start.
Yes.
So my name's Alana Doreen Dixon. I'm a physician applying for the California medical license for physicians and surgeons. First off, I just wanted to say thank you for the panel for letting me come and meet with the board. I know that it's not common for that to happen, and I'm sorry if I become a little bit emotional. This has been a kind of a whirlwind 2 years for me. So I believe the concern that we're discussing today is regarding professionalism based on records that were sent from predominantly from my previous training program, which I just left at the University of Minnesota. A large file that was sent from Dr. Matthew Hunt as chief among the concerns. There were multiple statements that were made, allegations that were made that had formed the basis, in his words to me, and I think also to the board, for a contract non-renewal. So I wasn't dismissed from the program. In the middle of my program, I was given 22 months of credit, but my contract was not renewed at the end of my PGY 2-year. I want to point out to the board that almost the entirety of that record that was provided to with regards to the statements from residents and even some of the faculty, certainly all of what's called the ad hoc determinations that were made there were entirely uncorroborated allegations. Some of it was hearsay, simply hearsay. Some of it was hearsay upon hearsay. And then as it moved forward, it became hearsay upon hearsay upon hearsay. That's reflected in both the official evaluations in the 360s, as well as in the emails that were solicited by Dr. Hunt. I believe in the hearing that we had previously, Dr. Service was under the impression that these were all extemporaneously gathered and that people volunteered these. However, Dr. Hunt admits, and this is in the administrative record in the hearing that I did on, I believe it was September 20th, 2017, that he in fact solicited almost all of these complaints. Dr. Hunt and the General Counsel for the University of Minnesota admitted this. They admitted that these complaints were not investigated, which makes them uncorroborated. He didn't investigate a single allegation, even in cases where medical record numbers for patients were provided, and I provided countervailing evidence that perhaps I had participated in something, but that it wasn't exactly the way that it was described. Dr. Hunt refused to take this information from me, and then he did not investigate any of it. The Attorney General received a letter from Brent Benward, who's the General Counsel of the University of Minnesota. I included that in some of the documentation, and it was emailed directly to the DAG as well as to the medical board. Dr. Hunt also sent an email which was submitted to Catherine Largaspada and Christine Thomas at the medical board. I've included it there because I didn't see it in the ALJ record. I'm not sure why it wasn't included in there. So I do offer those as offers of proof, and I understand that procedurally you may not accept that. I would also like the board to know a little bit about myself. I don't come from a wealthy family. I'm the first in my family to attend medical school. I come from a long line of healers. However, my grandmother was from a long line of nurse midwives, granny midwives as they call them in Louisiana, serving Creole people all throughout the state of Louisiana. She was the first in her family to go on for formal education, and she became a nurse in a 2-year program, one of the first programs available to African Americans in the country in Louisiana. My father was the first in his family to attend a 4-year university, and he became an attorney and worked doing civil rights and other cases, mostly pro bono, which is why we're not a wealthy family, I think much to my mother's chagrin. So my sisters and I have gone on, worked very hard, been encouraged to do education in a way that was probably a little bit excessive. We've all gone on to get PhDs, master's degrees. My sister was the first in our family to get a PhD, and this was my life up until this point. I sought out mentorship regarding whatever concerns were listed by the University of Minnesota. I have no infractions such as malpractice. I've never been arrested for drug or alcohol abuse. I've never had inappropriate sexual contact or continued and did fraudulent activities with my patients. And despite numerous challenges, I've remained enthusiastic about medicine and committed to the practice of medicine. I may or may not be suited for neurosurgery. That's something that was a question, but I have an opportunity to continue in neurosurgery, and I would like to do that. I was privileged to receive the endorsement of multiple faculty members from everywhere that I've trained, and I have tried to work on things that were identified as problem areas when I could and when they were legitimate. But I'm grateful to the board for giving me this opportunity to meet before you today, and I hope that I can persuade you to remove the penalty to my licensure. Thank you.
Have additional time left if you'd like to use it, but if you're done, that's fine. Okay.
No, I think that's
All
it.
right. Mr. Chambers?
Respondent is clearly well-lettered. But that's not the issue here. The issue was noted by Dr. Mark Service, who is the Vice Dean for Medical Education at UC Davis Medical School. He was the expert for the board in this matter. Dr. Service noted that the respondent had deficiencies in the 6 AGCME core competencies. For the record, those were patient care, medical knowledge, interpersonal communication, professionalism, practice-based learning, and systems-based practice. Dr. Service has oversight over the medical student education, which includes all residency fellowship programs at UC Davis. And when he wrote his report, he found that the respondent needed to pursue additional residency training within the highly structured and supervised environment of a residency training program where the danger to consumers would be decreased. When Dr. Service had the opportunity to meet the respondent, his position wasn't changed. He then came back and testified at hearing, quote, that he did not think, quote, it would be safe for the applicant to be given an unrestricted license, close quote. He further testified that the applicant should not be given an unrestricted license at this time. This was not based on a single issue. There were numerous problems that were identified at more than one institution. The record that has been presented at hearing and to the panel is thick. and it fully documents the issues about which Mark Service based his opinion. In light of the concerns for public safety as expressed by Dr. Service, we're asking that the board adopt the proposed decision. Thank you for your time.
Okay. Would you like to begin, Ms. Dixon?
Yes. Okay, I'm ready to begin. Thank you. I'm going to read a little bit from the statement and kind of jump around again. So it's, again, my pleasure.
Can you speak up just a little
Oh,
bit?
sorry. It's my pleasure to apply for the California medical license. I have both sides of my family are in California. I speak multiple languages and have cultivated a lifestyle in which I hope to serve members of the public, mostly American Indian, Asian American, and African American populations. This is my heritage, as well as groups that I have studied formally as an anthropologist and served in medical research, public health research, and in other areas. I returned to California after what was a very challenging time at the University of Minnesota. Dr. Service and the DAG rightfully point out that there were some concerns that were in my records from University of Southern California, Beth Israel Deaconess, and the University of Minnesota, which I would agree would paint a picture that there should be, further investigation or questions about my conduct. However, I want to point out to the medical board that I was at the University of Southern California and California Institute of Technology, completing an MD PhD for 9 years. In that 9 years, I had no disciplinary action until I took an exam, the Step 2 exam, and I had multiple pregnancy losses, as I've outlined elsewhere. I faced numerous incidents of discrimination, which I never talked about openly except to one person. That was Dr. Donna Elliott, my dean, and that was at the end of my medical career. I didn't make a big deal out of it. I just put my head down and worked harder and tried to be the best example that I could be of someone who chose to have children during medical school. But as a result, there were times when I just wasn't well. I became very ill during my senior year of medical school. For about the last 3 to 6 months, I was off and on struggling with upper respiratory infections, and it was difficult for me to take my Step 2 exam on time. I scheduled it, and as I have done in the past when I've had these issues, I had planned to just go on ahead and take it. 2 days before the exam, I became febrile and was completely unable to get out of bed. I had completed my rotation and was only supposed to be studying for the board exam. I planned on taking it and then just realized I was not going to be able to go on ahead and do that. I did contact my dean, but it was late, which was not characteristic for me. I've always taken those exams, even when I've been ill, and the dean was not pleased with this late response to her, and she asked me to go before the professionalism committee. My dean did not appear before that committee to discuss the charges that she had brought against me. In fact, the committee wasn't aware even why I was there. So we discussed concerns that I had. They asked me various questions, and ultimately no sanctions were placed on my medical school tenure. I wasn't asked to stay longer. I wasn't asked to do any form of remediation. And my understanding from the registrar at the school is that there's a standardized language that they use for our MSPE, which includes missed assignments and other things. But I didn't have missed assignments during medical school. I never failed an exam. I had no issues, interpersonal or otherwise, with faculty or students. There was some concern about some emails that I had sent, again, during that time period regarding tardiness to some clinical things, and those were not tardies that were due to my own issues. Those were things that came up in the course of doing procedures. I was asked to attend an aortic dissection surgery, for example, aortic dissection repair, because they didn't think I would see another one. That was the example that was given, and those are the things that had the DAG or Dr. Service contacted the medical school, they would have found out. There's no secondary file from USC of complaints against me, and there were no other things. So again, for 9 years, I was a medical student at USC. I took numerous national board exams and other exams. I took them on time. I passed them, despite the fact that I was actually often very ill. I had 7 pregnancy losses by the end of this time period. I'm sorry, 5 pregnancy losses by the end of medical school, and I still continue to go on. BID was a fantastic place to train, but it was very difficult. It is known as a program that, in some parlance, is considered malignant. I wouldn't say that it's that. I would say, though, that it's a very difficult program. I was not a general surgery bound person initially. I'm an MD PhD. I spent 3 weeks on general surgery as part of my required rotation, and then I was funneled into a cardiac surgery rotation because it had more relevance to neurosurgery. And as a result, when I went to BID, it was challenging. I was not intending to go into general surgery, but I had applied for both prelim and neurosurgery programs, and I was matched into a prelim general surgery position. I'm grateful for that time. It was a tremendous period of growth for me. In kind of the vernacular, I got my butt kicked every day. I think the first 4 months I probably cried 3 or 4 times a week, as did almost all of the other 20 residents or interns in that program. 10 of us were preliminary interns and 10 of us were categorical interns. I would say that all of us who were prelims are grateful that we had the opportunity to go to BID. A reference was made to comments made by Mary Jane Houlihan. She was a taskmaster. I was terrified of Dr. Houlihan, but I learned how to operate from her. I literally learned how to stand at a table. I learned how to be ethical. I learned how to behave as a surgeon. Most of all, I learned how to take responsibility and accountability for all of my actions. I was always told, you are the captain of the ship. Everything that happens under your watch is your fault, and you need to think of it as such. I think that training at BID was foundational, but I think moreover, what's missing from the medical board's understanding of that time at BID is that I was an average intern. The complaints about me and my medical record were complaints that most of the interns faced. We talked about it, we commiserated over it, and we tried to move past it. But mostly, it was transparent. There's nothing that's in that record that I didn't hear about, that I didn't have an opportunity to discuss. I talked with Dr. Houlihan, I've talked with Dr. Jones, I've talked with others who made comments there both during that time, on the days that they had complaints. We talked about all of those issues, and some of them are not as accurately portrayed as they could be, but I took all of the feedback from them, and I continued to try to move forward. What I learned from BID was to have integrity and professionalism and to work hard. This added to the body of information that I'd had previously. When I went to the University of Minnesota, I immediately began to experience subtle and overt forms of racial, gender, mostly gender, and age discrimination. The fact that I had gone to Ivy League institutions, that I had an MD PhD, was also something that was not liked. They had previously dismissed, even during the time that I was there, the same resident was there, they had previously dismissed another MD PhD and frequently compared me to him. I thought this was just normal hazing, but it escalated. I didn't find out until July of 2016, a month after I left the program, that the file that you now have was put together by my program director. Despite his assertions, again, all of this is uncorroborated, not vetted. He didn't even ask faculty, staff, nurses, patients about any of these materials, and he also didn't go to the medical record. A root cause analysis was performed even in one of the instances. I was not found at fault. In fact, I performed everything according to plan. My understanding is that when I was there, I've done nothing that warrants a malpractice investigation. I've never been accused of killing a patient. I've never participated in anything that led to that. And with regards to the ACGME milestones, I've discussed this with the ACGME office itself, and I've asked how these are supposed to be used. I've discussed it with the GME head. These milestones track out over the course of a residency. As a 7-year program, neurosurgery residents will not achieve those milestones by the end of residency. And according to the ACGME, these are not to be used for high-stakes decision-making like dismissal, probation, or ascension in the ranks. This is my understanding from the ACGME. They do give wide latitude to programs, and I think it was right that Dr. Hunt was concerned about those things. However, in the record, I think you'll also see that it's very conspicuous that the one count of accountability on which everything hinged for me to pass my probation, I was at the appropriate numbers on the Likert scale, and then I was below it when I was in my probationary period. I think there was at times a concerted, if not always intentional effort on everyone's part, but there was a concerted effort to make statements about my performance to fit a certain narrative. And I think that narrative was established when I came. I was lazy, I was too dark-skinned, I was not deserving of my MD PhD, I ate all the time, I was fat, and I was unaccomplished. Those were the messages that I heard literally in those words from people when I was there, and those are the messages that I think are certainly portrayed within that file. I can't change that fact. I wish that I had known that it was going on. I wish that I had left the program earlier. but I didn't. I was told even up until the end, and even until my last day, I had no privileges revoked. I saw patients at 4 hospitals. I carried the pediatric, the adult service at night. I operated even until the end. I have my ACGME case log, if that's allowed to be admitted, for the last 3 months. I had no restrictions, and in fact, my final night of call, overnight, I had no chief resident, and my faculty attending, Dr. Hunt, asked me to do everything on my own. He asked me why I was calling him, and I was tasked with seeing multiple patients admitting and discharging from the ICU and the emergency department without anyone there because 2 of the chief residents were fighting and they didn't want to take call that night. This was my experience there. On a personal level, however, I did learn a lot. It was very stressful. I lost 2 children in the 2nd trimester. I watched them die on my chest. I didn't talk about this with other people. In fact, most of the nurses and other staff didn't know I had even lost the pregnancies. They assumed that I had been pregnant, that I had the children at home, and they would often refer to me as a mother of 3, when in fact I'm a mother of 1. I was described as professional even until the end, and I tried to remain that way because I think that patients are put first, and that's my training at USC, University of Utah, Yale, all of the clinical sites that I've been to from Los Angeles to Hawaii, all of my preceptors, and in addition to my own family work ethic and the information that I got from my grandmother growing up about caring for patients. So despite my own personal challenges with discrimination there, with pregnancy losses, I showed up to work every day on time. I went to all of my clinical duties, and I continued to perform as a resident at my level. The question is whether or not this is adequate to receive a license here in California. My understanding is that we make these decisions based on evidence. Everything that's presented from Dr. Hunt is not evidence. It was admitted as administrative hearsay. Although Dr. Service has made, I think, an excellent judgment, if these were all true, they're not true. He did not investigate, neither did the DAG. So they don't know what's true and what's not true. And it's all very easily verified. For example, my pager log. If you look at my pager log and you cross-reference it with my cell phone log, which I did at the time that I was a resident, there were not times when I just didn't answer my pager for 30 minutes at a time. There were times, however, when nursing staff, either they were too busy or they just didn't want to, didn't answer my pages. That happens to all residents. That happens to all surgeons. That's not something that's unique to me. However, it was a challenge for me because I was already being positioned as someone who was inadequate. I tried to work and do my best to deal with this, and I'm sure that at times I failed. I wish that I could have been better. People have advised me not to mention my mistakes or not to mention my weaknesses, but that's not me. In fact, all of the descriptions of me, it's interesting because there aren't very many quotes. There aren't quotes to say when I refuse something. There aren't quotes to say how I refused it, how I yelled at patients, because that's simply not what I do. I tend to be quiet. At times when I'm gregarious, it's because I'm laughing and I'm enjoying myself. I don't drink coffee. I don't drink alcohol, so I have to stimulate myself somehow to stay awake. So I walk the halls. I see patients. I talk to nurses. I engage. I try to be helpful. When I perform procedures, I try to do them to the best of my ability, and I ask for help when I don't know how to do it. University of Minnesota was an interesting mix of a very opaque culture. As a cultural anthropologist who did field work, I had a very difficult time figuring out what the culture was there. In contrast, Boston was not so difficult. It was very direct. It was very clear. I would get expletives thrown at me. I would be yelled at. I would have things thrown at me. These were all experiences that all of us had, and we took it in stride and made it better. University of Minnesota was very different. For the most part, everyone was pleasant every day. I learned a lot. It was an amazing experience. But on the other side of it, it was very difficult to get accurate and honest feedback. I found that many of the people that had made positive comments to me made negative ones in emails, but we never talked about it. And I didn't see this until July 2016.
Ms. Dixon, I'm sorry. I let some of your note of time from your intro because you
Okay.
had additional time.
Okay.
I let you use that in your rebuttal,
Okay.
but we're up to the limit on
Okay,
that.
perfect.
Okay?
Thank you.
Mr. Chambers?
There's been absolutely no question that Ms. Dixon is well educated and that she's a nice person. But that's not the criteria for licensing at this juncture. She never had privileges revoked while she was at the University of Minnesota, but she was put on a remedial period. And when that didn't work out, she was put on probation. And when that didn't work out, they did not renew her contract. It happens every now and then, but it's not common. And Dr. Service testified to that. Dr. Service has testified as to how long he'd been involved with teaching at the University of California, Davis, and in the administrative process of overseeing students. And when he says that she should not be at the residency program at University of California, Davis, that carries a lot of weight. Now, there were comments about Dr. Hunt and whether he did a sufficient job at the University of Minnesota. We can only go on what the University of Minnesota provided us, and they gave us a lot of documentation, including documentation from a Cordon Quinn, MD, who wrote on June 25, 2015, no matter, quote, no matter how many times we repeatedly tell her about discharge orders, there are continuous mistakes. Not controlling BP on both post-P patients, IV pain medication only, no labs, mixing up and confusing patients, etc. Even today, she had another never event. She confused patients and discharged Dr. P's patient, SR. She thought this patient was a trigeminal neuralgia patient and discharged her as such. I caught the mistake and paged her from clinic. She told me she mixed up patients, but all the other orders should be correct. Only that this patient being admitted and not discharged. Close quote. This is a very serious issue, and it came to judgment with regard to scientific and medical issues, not on personality and not on academic achievements, with regard to whether one has a bachelor's or master's or PhD. And the record was replete with incidents at Beth Israel, at University of Minnesota. And that's why Dr. Service, based upon all the information provided to him, had to make the decision she was not ready. He felt she should do a residency somewhere else, but she wasn't ready to do it in California, and certainly not a fellowship. So at this point in time, we believe that the proposed decision should be adopted. Thank you.
Okay, at this point, I'm going to open it up to questions from the panel, the board. If we're going to start, if we have any questions on this side at all. Any questions? Go ahead.
Absolutely. Mm-hmm.
My understanding, 3 of the residents are female,
Mhm.
and 2 of them at least Indian heritage, and 1 is Asian.
Mm-hmm.
So let me ask you to explain how you feel that you're being discriminated.
Initially, when I was there, actually, I didn't perceive that. A lot of the incidents that happened when I wasn't there, and I would hear about them from other people. I did have so this is initially, I had just some microaggressions here and there, comments about my weight mostly, a few comments about Native American patients, for example, that all Native Americans are alcoholics and inbreeds. That was from Molly Hubbard. In addition, and I don't know what your experiences have been, my experiences in California have been mostly positive. I mean, when I've worked with other women, other Asian Americans, it's been positive. I think the culture here lends itself to that, for people to feel very confident in who they are. What I didn't understand is I think that some people come from regions of the country where they are in the minority. Certainly in neurosurgery, women are in the minority. And if you're in neurosurgery, which this might be an insight that some people find difficult to endorse, I've talked with my mentors about it. Women in neurosurgery, there's so few of us, and programs that have more than even one woman or more than one woman, if you talk to most people in neurosurgery, the program will be described as a deficient, low-level program, something like that. People will look at the number of white males in the program just based on the face page, the residents that are there. They'll look at the number of women, and they will make determinations on the quality of the program. I don't agree with that, but that's something that is found in neurosurgery. And so what I found when I went to the Midwest, and I'd never lived in the Midwest before, is that many of the residents had come from Midwestern states or places where they were in the minority, certainly as a woman in neurosurgery. And I think that to a certain extent, and these were statements that I was told by others and directly by the other women in the program, women in neurosurgery can't afford to mess up. You can't afford to have children. You can't afford to be any different than your male colleagues. And although I would say I think half of the men in my program, so there were half women, almost half men, half of the men had children and were actively continuing to have children, including Quorum. but the women weren't. And in fact, only one other woman besides myself was married, and the others had said they weren't going to get married. They planned on not ever having children. They went to my program director and my mentor and others and said that women in neurosurgery should not have children. I think it's actually a very common thing to find among women. And the Asian American woman who was there, Zoe Zhang, was very perplexing to me. But she, even though she speaks Chinese fluently, chooses not to speak it. She doesn't like to be called Asian American. She anglicized her name, and she and Molly Hubbard, I think I mentioned it in my documentation, had a conversation in front of me. I don't know if they recognized that I was there or not, and they should have, in which they said that Asian American women were difficult to work with. It was during interview season, and that they specifically didn't want a specific Asian American woman to come to the program because they didn't like Asian women. I relayed this to Dr. Hunt and to the others, and was told that that was irrelevant.
I'm not
Sorry,
sure
I
it's
don't know if I'm
considered
taking too
new
long.
evidence that you mentioned the incident was reported to the
Yes.
Equal Opportunity or the Human Resources. Was the investigation closed? What was the outcome?
They did do the investigation. In the hearing transcript from September 20th, 2017, Dr. Hunt reads their letter. I have some concerns about that investigation because it wasn't, I guess in Minnesota, they don't actually do investigations in the way that we think of it. They talk to people, and then if a statement is made that is accurate or inaccurate, they wouldn't know. So, for example, they stated that I took my neurosurgery board exam, the primary ABNS exam for junior residents during my first year, and failed it, and that was the reason that they wanted me not to stay on as a resident. As a rule in that program, and historically, we take it as second years. We take it for practice, and almost everyone fails it. And that's actually nationally. The people who take it for credit, over 90% pass it. But you typically take it for practice 2, 3, or even 4 years. So that was an example of an inaccuracy in that. And I think throughout that report, there were also other inaccuracies that were pretty significant, people that weren't interviewed, medical records that weren't reviewed. So I forget what it's called, but the consultant who came to do that found that there was no discrimination. I think it was very subtle in some instances. I think they did an excellent job of covering it up. And actually, initially, I didn't want to admit that I had been discriminated against. I sort of come from this pull yourself up by your bootstraps family, overcome any challenge, and I don't typically talk about discrimination. My father, though, who had been he's retired now, but he'd been a civil rights attorney for many years, identified very early on when I came there that some of the practices and behaviors were discriminatory, and he encouraged me to try to protect myself as much as possible. And I just didn't think that it was happening in the same way that it was.
So the investigation is closed by the Human
it's
Resource?
by the Equal Opportunity Office at the university, but it's now, in fact, I just got a call this morning from the Minnesota Department of Human Rights because they're doing the investigation. So the University of Minnesota sent that material, I think the report from the EOA, as well as their own statements, and the Minnesota Department of Human Rights still has the charge of discrimination, and they're investigating it now.
Thank you.
Other questions on this side?
No.
Good morning, Dr. Dixon.
Good morning.
It's pretty brave to come here and represent yourself. So it's a challenge sometimes.
Yeah, definitely.
We've talked about discrimination, and we
Sure.
can put that away for now.
Absolutely.
For me, my more concerns are competency,
Absolutely.
along with the other issues. And when I'm reading the file, I noticed that there are comments from various physicians that you might be perceived as having trouble being difficulty being a team player. And I've circled places all throughout here about where was it? Hold on. In my page 9 here, it says clearly applicant faced difficult and painful challenges when she was resident relating to her pregnancies and ongoing conflicts with several residents.
And this
So
is
I
from Dr.
see that
Haynes.
in there, and I saw it somewhere else too.
Is this from Dr. Haynes? That statement's from Dr. Stephen Haynes, the chairman of the department. I think.
Let's see.
I guess-
Minnesota. Clearly applicant.
I think that's from Dr. Haynes, if I'm
Yeah.
remembering.
Okay. Yeah, I don't see a name that's. But Dr. Service. It was part of Dr. Service's paragraph in
Sure.
here. So I see that.
Mhm.
So I want you to comment on that comment.
Mhm.
Here's Dr. Hunt. Dr. Hunt noted that while applicant was able to work with multiple teams, at times her ability to work as part of the team was compromised by difficult team dynamics. And part of being, a physician is being able to work in a team and also to accept criticism. And there were comments in here about your not wanting to accept criticism, and that concerns me. So I would like for you to comment on why those comments are in here, briefly, if you could
Yeah,
tell
absolutely.
me. Thank you.
Firstly, I didn't have those complaints in medical school. I worked over 110 hours a week in neurosurgery and on other specialties during medical school, so that was not an issue in medical school. I think if you want me to go directly just to the comments from the University of Minnesota, I'm absolutely willing to do that.
I would narrow it down to
From
my
Minnesota?
Sure, because,
absolutely.
it's fine medical school, whatever, but here we're dealing with your residency, which you
Absolutely.
need to meet core competencies, which in the team dynamics is part of that.
Part of that.
And
Mhm.
right now, I don't see that you have satisfied that core
Mhm.
competency.
Absolutely.
And Dr. Service has other comments too.
Some concerns
But if
about
you
that.
focus on
Yeah,
that,
okay.
please.
My understanding of those comments is from the faculty's perspective, and this is what I was told by Dr. Hunt and Dr. Haynes and others themselves. They didn't see any direct evidence of it, is my understanding. They heard about it from the residents, and they saw evidence of it in outcomes with, things that were supposedly missed or opportunities for patient care that were missed. So what I can say about that is a lot of those incidents I wasn't actually made aware of when I was there at the University of Minnesota, and so I often couldn't respond to it. What I did experience is, and I don't know if this is going to make a lot of sense, but I'm an older resident. I was about 10 to 12 years older than the other residents there. I was a journalist, an anthropologist, and I did a PhD in science. And so my way of interacting and my way of asking questions was not typical. And I think that from when I talked with my mentors, for example, at BID or University of Southern California about these exact scenarios, some of the ones that came up, one of the things that they gave me insight on was they said, Alana, you come in, and a lot of people, because you look younger, they think that you're a resident. But then when you start talking in the way that you hold yourself, you appear like you're a faculty member. And for some of the residents, that can be disarming. And so you need to find a way to let them know that you're still willing to play within the hierarchy and that you respect the hierarchy. And I do. But for example, I'm not afraid of my chief residents. And so when I ask them questions, I think within the context of residency, it's not that you have to have a fear, but there's a certain deference, and I try to pay that deference, but I think I've worked for a long time, I've been independent, I've run a company, I've done certain things, and so if, for example, there was a question about patient care, and I came in and I was asked about that, I would say, yeah, this is what I did, this is what I intended to do, these are the ways that I was going to handle it differently. And what I have been instructed to do instead, especially by Dr. Hunt and then by my program director, Dr. Kent, is that at times it would have been better for me not to say anything, or to come in and to be a lot more demure and just, and I know that this seems like it's all interpersonal stuff, but when it mostly came out in situations, for example, with Corden Quinn gives these examples of patient care issues. When we're in clinic, we don't see the patients. When we go to clinic early and we do procedures, we don't get sign out. We don't get to hear rounds. You don't see the patients. And so often things were given to me by Corden. Actually, specifically, Corden did this all the time. He would give me patients to discharge. That's a team responsibility, is to discharge patients. I tried to do that to the best of my ability. I didn't always know how to communicate to Corden, so I communicated it to my program director that I didn't know those patients. I hadn't seen them. I hadn't gotten any sign out about them. And so I would try to do things to the best of my ability, again, trying to be demure and just sort of do the work. But in my opinion, it was challenging because there was a systems issue. We didn't do that at BID. We didn't do that at USC. If you admitted the patient or operated on the patient, you wrote their orders. If you were the person on call, you discharged the patient. And so Dr. Hunt actually agreed with that, and that practice stopped. And so those were some issues. But I think the other larger thing is I'm still learning. As a second-year resident in neurosurgery, it's very different from general surgery. General surgery was extremely hierarchical. Everyone knew their position and their place at all times. And when I went to the University of Minnesota, that was not the case. And so I had to adjust to that. I spent almost all of my first year with general surgery. And if you note, there aren't complaints about interpersonal dynamics, team dynamics, failing to do things from the general surgeons. In fact, they write letters of recommendation, and their 360 evaluations are generally not at all in that direction. So I had sort of learned how to do that in a general surgery context, and during my second year of neurosurgery, I was learning how to do that in the neurosurgery context. I do think that, and I've talked to professional coaches about this since then, I think that there are ways that I ask questions. Again, I was a journalist. I tend to ask questions very directly, and sometimes that's not the way to ask a question within that hierarchy.
I need to interrupt you for
Absolutely.
sake of time, but you picked neurosurgery,
Mhm.
which I don't know, I mean, maybe you love neurosurgery, but
do.
it is a different world in neurosurgery, as a lot of the surgical subspecialties, and I want to know why you pick such a sort of
Yeah.
intensive program, and I hear now just excuses.
Okay.
That's what it sounds to me. Well, I'm still learning. Well, it wasn't this way here. But, you know, I was in medical school, and you learned from other residents, and so how you're supposed to act and behave, it's, it's sort of a club, and you just don't seem to kind of get it when I hear you. So I just, you know, I'm having trouble understanding that because I just hear excuses, and I'm not here today to,
Sure.
well, I was here and I was there, and you see what I mean?
yeah,
But we
I'm
could
not-
go on to other people in the panel and ask, but that's my concern.
Yeah, and
as I read.
I'm not really sure how to address it. I can only address what I know, and I can only say what I actually worked in many of the teams there, including in neurosurgery. There are 7 other residents who didn't make comments about me with whom I worked, and very well. There are 7 other residents. There were 3 other chiefs who made no comments. Actually, there were 5 other chiefs who made no comments about me. The only chief resident there who did was Zoe Zhang. I don't know what else to tell you except that I try to do my best, and I don't make excuses for my behavior. I just discuss it openly. It is a club. Neurosurgery is a huge club of very specific types of people and behaviors, and I wish that I understood all the minds and the options that were available for my behavior, but I can only be me and try my best to fit in.
Okay, thank you.
Further questions?
No further questions.
Okay.
Good morning.
The attrition rate is for a neurosurgery residency program?
It's actually pretty high. I don't know the numbers off the top of my head. It's interesting that the DAG mentions Dr. Service's experience with neurosurgery at UC Davis. I understand he's been there for over 25 or 30 years. University of Minnesota is very different. They actually lose a resident historically almost every other year. Even during the time that I was there, they had 3 residents, including myself, that potentially were going to lose their positions. The other 2 went through remediation and they passed it. That's my understanding. I didn't talk with them directly, just Dr. Hunt and the program coordinator. Another resident was dismissed from the program after 5 years there. It's really not uncommon at all. And if you look at the attrition rates for African Americans, Latinos, and women, it's even higher than for Caucasian males. And so it's fairly common. I think UC Davis, I'd interviewed there before, and I really loved the program. And they don't really lose that many people. There are lots of programs around the country that are like that. Columbia's like that. Stanford is like that. USC, where I trained, has a relatively high attrition rate. I think they also lose probably 1 every 2 to 3 years. And that's not so much because of interpersonal dynamics. It's mostly because they work really hard and people just decide it's not for them. And so there's that component of people just coming into neurosurgery and deciding that they don't fit, that it doesn't fit with their lifestyle or their goals, it's not what they wanted it to be, or they get fired, or like me, they get their contract not renewed. So it's pretty common.
And not to ignore the fact that you were mixed race, but were you the only African?
Yes. Yes.
And then just for the DAG, I'm just wondering, the expert is a psychiatry.
He is psychiatry, and,
Right.
and so I could not speak to the attrition rate with regard to neurosurgery,
No, that's not my
nor did
question.
Dr. Service.
Yeah. I'm hearing that neurosurgery is a club, so there's a sort of distinct way that it operates. I'm wondering why there wasn't an expert that was neurosurgery focused that opined about Dr. Dixon's ability and conduct. And maybe it doesn't matter, but that is something that is a little bit concerning to me, that it's not something that's a specialty specific, if it in fact it's a club and there's an attrition rate that's, that high in that particular residency.
The applicant applied for a general license in California. And with regard to general licensing, the board looks at these 6 core competencies. So with regard to the evidence that was presented to the board through the application, the experts are brought in to consider whether that person is qualified based upon the core competencies. So those core competencies, while they were graded by individuals at the University of Minnesota and at Beth Deaconess, or Beth Israel Deaconess, those were not all simply neurosurgery. Minnesota was, but Israel Beth Deaconess I don't believe was. And so the core competencies are considered by an individual who was in the education field at the University of California, Davis. In this case, it was Dr. Service. In other cases, we've used other individuals from that university.
Okay.
I don't know if that was sufficient for your answer. But
Yeah, I guess I'm just sort of uncomfortable, and so I'm wondering if there's any distinctions, and I'll move on. If one is in a neurosurgery specific residency, and the core competencies, how they equate. Maybe it's just a core competency across the board, and it doesn't matter. I'm unclear, and it makes me slightly uncomfortable.
Understood. And because we did not elicit that testimony specifically,
Okay.
I'd be very uncomfortable proffering a.
Yeah, again, I don't
yeah.
want you to stray into attorney-client privilege
I'm
land.
I'm not in
Right.
the least bit. I'm just, for the purposes of evaluating this individual
Understood.
doctor. Yeah, but I will move on.
Another question on this side?
Thank you, Dr. Dixon. So I don't want to go and be repetitious too much, but I would like for you to, if possible, to broaden, expand on Dr. Lewis's concern about professionalism and dealing with faculty, patient, et cetera. You reflect a lot on the experience, and that's in the record. And if I can ask you to talk about what you've learned and what you would use going forward if you're ever given a license, because we all hopefully learn from our experiences and build on that. And there are some comments in the records. You've explained some of them, and certainly pick up the ones you think are important. But going forward, you're going to encounter the same things we all do as a physician. I'm a physician. I've been in practice for 30 years. And I learn things all the time from my patients and my peers and conferences that I go to and from this board. I'd like to get a better feeling about that rather than what happened then.
Absolutely. I'm just a pretty straightforward person, and so when I hear comments from people, I don't think of them very passionately. I try to understand, and this may not make any sense, but I sort of look at it as spaghetti on the wall. People throw a lot of spaghetti noodles on the wall, and some of them are relevant to your experience, and some of them aren't, but all of them are there, right? And they were thrown there for a reason. People want them there for a reason, and so I try to look at it in its totality, and this is how I've kind of always done things, but certainly this experience has taught me a lot. Medicine is very different from anything else that I've done before, and I found a lot of success. I don't think it's all recorded here, but one of the ways that I think I've moved forward and also plan to continue to move forward is every time there was something that was uncomfortable, maybe a patient interaction that was negative, I tried to look at it from that patient's perspective. You know, I've been a patient. I've almost died several times in the hospital. And I tried to look at it from the perspective of what if I were in the bed as that patient and someone came to me and said X, Y, or Z, or someone didn't share this information, or someone did a procedure and I didn't understand it, or whatever the concern or complaint was, or what if it was a faculty member or a classmate, a cohort member. I try to look at things from their perspective, and I try to do that even still. So with regards to, for example, the question about, teamwork, I would look at things, and I continue to do this and say, well, if I were that person and I were giving this, complaint, how is the way that I'm behaving perceived in such a way that's negative? And if I can answer that question on my own, and then I try it out, and I have success in that way, then fine. If I don't, I go to mentors, I go to others, I go to people who know me well, and I ask them to reflect. I give them the scenario, and I try to reflect on it, and then formulate a plan. So, for example, in this case, I actually don't generally have problems working in teams, but this is a concern that has come up. And so one of the things that's been recommended is to go and see a coach regarding that. I have no problem doing it. It would be great to have a job, to have the extra money to do that. I don't have that right now. I mean, I am working, but I can't afford it. But I will continue to take advantage of those types of opportunities to do that. And I think that if there are other things that I can do, I'm very open to them, and I've continued to be open to them. But I've continued to do all of my professional licensing, CMEs, and take classes and do things like that.
Thank you. And the last, just briefly, the question of competence. And there are things that we look at, and we look at the ACGME's 6 core competencies. Do you have a feeling about that? Some involve professionalism, interaction, but others have to do really just the practice of medicine and the problem solving. I mean, what's your comment about that?
Regarding my performance evaluations, is that, or just the ACGME core competencies in general?
Your performance briefly, but really going forward. I mean, do you believe they're accurate? Often in training programs we get feedback about what we did correct and what we did wrong. And sometimes we don't get the answer then because not all the information is there, and we accept that. We get the answer later because more information is available. Some people have trouble presenting cases. Some people have problems with their workup. I'm just trying to get a better feel. We had about your perception about your ability to practice medicine as a doctor and do the kind of detective work that's often required. Surgery is one thing, and one does things with, I guess I'm not a surgeon, and approaches how you do that procedure. But in medicine in general, it's a lot of detective work. And so we all have to get better at doing the detective work that's required to answer the question before us and solve the patient's problems.
I have some experience with the ACGME because they were new when I started internship at BID. I think that was maybe the first year that they were rolled out, according to my program director at least. So I was familiar with them. We talked about them a little bit during medical school. I think they're great. I mean, I think it's an important thing. I've certainly had a lot of physician-patient interactions where I've been the patient, and I wish that my physician, my surgeon, had been trained in these ways. As a resident, in all the places, I took the feedback that I could, and I tried to move forward in positive ways. I asked for advice on how to change things that were brought up, and I think I would continue to do that. I think as a person who's applying for a general medical license, I'm not planning on putting out a shingle in California. I really would like to continue residency here, and there are opportunities to do that for me, but I have to have a license because I've had 24 months of postgraduate training. I have no interest in practicing primary care medicine on my own. Certainly couldn't be a breast surgeon or a neurosurgeon or a general surgeon in any setting on my own. I do think I need more training. I think absolutely. I think also, though, that there is an important distinction between finishing a residency and meeting those ACGME guidelines in your first and second year of residency versus later. Some of them I can meet now, and some of them I just can't. So some of the leadership stuff, even some of the components of professionalism, as they're outlined, at least as I understood them from my GME dean and also from the ACGME, they're designed to be spread out because there's certain things that you won't do. Like I won't be a chief until the earliest my 4th year, my 6th or 7th year in neurosurgery, whereas you are a chief in 3 years in other specialties. So I would have already been a chief because I have PGY 3, years of training. So I can't change those things, but what I can do is work on the other core competencies. And I actually delayed going to medical school in part because some of the stuff that's in there before it was outlined in the ACGME guidelines were things that I thought a lot about. I think it's important to have intercultural, conversations with patients in a competent way. I think it's important to be professional. I think it's very important to be accountable. I saw a lot of lack of accountability for lots of, different levels of providers in my own personal, situations as a patient and in my training. And I think it's important to continue to try to be accountable and honest and, professional in every way possible. That's not only a goal, it's a commitment of mine.
Thank you. So I'm finished.
Other questions from anyone on the board? No. Okay, all right. With that, as you know, there won't be a decision today. It will come further later after we've closed the record here in writing from the board. So with that, the matter is submitted and the record is closed. I can get you a copy of the court reporter form here in just a second. Hold on. Yeah, so we will be going into closed session, and so we need everyone to leave the room, except for the folks who are about to wait for their court reporter form. I'll give you that, and then we'll... All right, I will open the record in the oral argument in the matter of the accusation against Umberto Augustin Florian, MD. This bears case number 8002015-010854, Office of Administrative Hearings number 2018-090521. My name is Deborah Nye Perkins. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned today to sit with the Medical Board of California and they are in a quorum. I could have the members introduce themselves one by one, please, for the record, beginning on this side.
David Wormuth.
Dr. Ron Lewis.
Jamie Wright.
Dr. Randy Hawkins.
Thank you. If I can, please have an appearance of the attorneys, please, beginning with the Deputy Attorney General.
Good morning, Your Honor, members of the board. Supervising Deputy Attorney General Matt Davis on behalf of complainant Kimberly Kirchmeier.
And who do we have for Mr. Flor or Dr. Florian?
Larry No. I'm appearing for Dr. Florian, the respondent.
And is Dr. Florian here today?
No, he's not.
All right. So just a little bit of the ground rules, as I'm sure you're all aware, with regard to this oral argument. The parties are allowed to present oral argument, but no new evidence may be introduced in this oral argument. The panel members may ask questions, but they may not ask questions that would elicit new evidence. And as you know, there are some time restrictions that we are going to enforce here today. So how this proceeding will proceed, Mr. No, you'll be able to present 15 minutes on behalf of a respondent of your oral argument, and then after your 15 minutes is complete, then we'll allow Mr. Davis to present his 15 minutes in rebuttal. And then after that, Mr. No, you'll have 5 minutes in rebuttal, and then Mr. Davis would have the final 5 minutes. Okay? And with that, if the parties are ready to proceed, Mr. No, I will start I'll be keeping time. If you'd like for me to give you a hand signal for 2 minutes to the end.
That'd be fine.
Okay. All right. In that case, Mr. No, I'm going to go ahead and start the clock.
Thank you. Yes. As you're aware, Dr. Florian has a charge from year 2014. Dr. Florian's been a doctor for approximately 55 years. Since 1974, he's been a doctor here in California. He has his own medical clinic at this time, and that's where the incident occurred in 2014. From the record, it appears that there was some type of discipline in 1984, and he successfully completed a probation in 1984, and then completed the probation in 1994. So he was on 10 years. But soon after that, I think he started his own practice, his own clinic, and he's been performing as a sole practitioner in his own clinic since the 1990s. He, for those 20 years before 2014, he had a clean record. He did not have any problems, any complaints. This was an incident that happened with one patient, and over a few months period of time, the patient came in to see him for medical, for treatment having to do with a surgery that he had, and that was the reason for the initial contact. Unfortunately, he did not, it appears that he may have not adequately read the reports that were given to him from the chest x-rays and stuff, and that's why we're here today. Dr. Florian has had, as I said, has been practicing solely for, well, over 20 years, 25 years. And he has, and this is the only one since 1994, at least actually from 1984, that we've had any type of problem at all. He is requesting that he be placed on probation. The revocation that is recommended, or that was ruled by the administrative law judge, I think is extreme. Section 227 of the code allows for various methods of discipline, and one of course, is revoking the license, but another one is to be put on probation. Since he was put on probation before, he was successful in completing his probation. And I think there's no reason to suspect that he would not be able to complete it this time. He is aware of the things that would be required, the monitoring, the classes, the payment that he would have to pay out to be on probation. So he is aware of that, and he is willing to accept the board placing him on probation. The protection, it was brought out, and I think in the brief of the AG, about protecting the public. Since 2014, we don't have any incidences. We have a clean record, except for this one particular patient. And I think that to protect the public, it would be probation. It would be the adequate remedy, and not revocation. He would have to have a monitor. He would, and he has already contacted other doctors that would be available to do that. So he is prepared to be on probation to do the courses, the educational requirements, and the requirements that are in the regulations. He to protect the public. I think the probation would be the adequate reason. It's not to I'm reading the case law. It's not to basically punish the doctor to protect the public. The public can be protected adequately by placing Dr. Florian on probation.
Okay, all right. You have some time left if you'd like to use it, but if you're done, we'll go ahead and start your 15 minutes, Mr. Davis.
Thank you, Your Honor. Counsel's correct. This is a single patient case. And in this case, respondent saw the patient on 5 occasions between March and July of 2014. At the initial visit, he rightfully ordered chest x-rays of this patient. On April 11th, the chest x-ray was performed and the lab result came back indicating that there was hypoventilatory chest with diffused increased interstitial markings noted. Comparison with previous chest x-rays, if available, is recommended. If previous chest x-rays are unavailable for further review, further evaluation with a thin section CT examination of the chest is recommended if clinically indicated. Subsequent to that, the respondent saw the patient on 4 additional visits on April, May, June, and in July of 2014. At each of those visits, he failed to discuss or document any discussion of the abnormal chest x-rays. He failed to request any further evaluation. He had multiple other signs that this patient had a problem, including shortness of breath and significant weight loss during that period of approximately 20 pounds in 4 months. The problem here is during his subject interview, and then again at hearing, the respondent said these films were normal, despite our expert, who was the only expert that testified at hearing, clearly indicating the films indicated interstitial lung disease as noted by the radiologist that read it. The respondent maintained that the films were normal, I did everything right, I would do the exact same thing again. That's what takes this case out of a probationary posture. We can't put a doctor who doesn't recognize what happened here and assures us that he'll do it again back into the stream of patient care. That's not public protection, that's putting the patients at risk, and it's inappropriate in this case. Thank you.
Okay. A rebuttal?
As I indicated before, having a monitor and having him attend the classes, and especially having him attend a class on adequate record keeping would be, again, helpful with the public. So I don't think, we're putting him out there alone. We're putting him out there with a monitor, someone who will oversee him and make sure that he is following the procedures. So I think the probation is adequate, to, especially with the courses that will be required, the professional programs, the clinical competency assessment that would be needed to be done. Those things are items that would protect the public, and I think if he follows through, I mean, after 55 years of practice, and being a doctor, I think that he has earned the right to see that he can follow and basically rehabilitate himself as far as this client goes and with the public.
Okay. All right, then final rebuttal.
A practice monitor won't fix what went wrong here or what currently remains wrong here. Practice monitor evaluates about 10% of a doctor's chart and submits reports to the probation department. They don't stand in the shoes during times of judgment of the probationer. As I've said, this doctor thinks those films were normal and assured us twice. He assured us at a subject interview that he would do it all over again the same way and that he did everything right. After the benefit of receiving the board's expert report that pointed out the shortcomings and extreme departures, at hearing he still maintained that I did it all right, I'd do it again. No practice monitor is going to fix that. By putting him back into the stream of patient care, what's going to happen the next time a patient shows up with abnormal interstitial findings on an x-ray? He's going to do the same thing he did here, and we know how that turned out here. We can't take that risk. Thank you.
Okay, I'm going to open this up to questions from the panel, or from the board. Beginning on this side, do we have any questions? No?
Yeah, I also have some problems about, I'm not sure that probation is the issue here, that because the misreading of the X-ray and
I'm sorry, I'm just a little confused. Is there a question that you
yeah,
have?
there is. I was also concerned with the what to me sounded like confusion over what drugs were prescribed for the blood sugar problems, and I'd like to know how you feel, or how the I'm sorry, I'm struggling here. How we can get by the fact that I'm not sure that the question is more competency than anything else at this point.
Well, as far as the at the hearing, there was a problem with Dr. Florian being able to hear as far as the questions and as far as Dr. Sue. I was sitting next to him, and he did have a problem with understanding what she was saying. And I think maybe there was some confusion, as you indicated, with the drugs that were prescribed for diabetes. And as far as his responses there could have been a problem there. That was just something that came. Let me turn this off. I apologize. I thought I had. I'm used to court, and I usually turn it off before I go in, but I forgot today. I apologize. So anyway, as far as competency, I think I don't know how to address that since I'm not a doctor, but as far as I think he's been in practice long enough that he has shown that he can be competent.
Other questions?
Mainly, well, I asked both of you the question. I'm unclear on Dr. Florian's current work location, number one, because I don't know. He's a solo practitioner in a clinic, and I need to know about the clinic, where it's located. Is it in a rural area?
It's in Anaheim.
Oh, it's in Anaheim,
It's
major
Anaheim on
metropolitan.
Euclid
Okay.
Street, yes.
So he has a referral base of other experts that he could.
Sure.
Okay. And do we know about his office staff? Is he by himself, or does he have LVN, RN? And the reason why I ask this is I didn't know if there was any procedure regarding signing off on abnormal tests that come in from either the lab are the radiologists. I didn't see that in the record. So to miss the chest x-ray and not to be aware of that was abnormal.
I don't think I can address that totally. I know he does have a staff. As to what their qualifications are, I cannot address that. But I
Okay,
know there's
well,
that. He's got about 4 or 5 people that work for him.
Okay. Do you have anything to add to that?
Well, I think missing the lab report coming in is not really the issue here. The issue is, after he became aware of it, he still maintains that that film was normal and that he did everything right. So whether there was a mix-up at his office regarding getting the lab report to him, I don't think really speaks to the ultimate issue, as Mr. Warmoth pointed out, competence here.
Well, sometimes there's systemic issues
Oh, I
that
agree.
contribute to, but you say he looked at the x-ray and he signed off on it and he said it was abnormal. I'm not aware of Dr. Sue. I don't remember seeing the qualifications to be the expert.
Dr. Denise Sewer, I believe, was the expert in this.
Well, I must have missed it in here, but I don't know what who is she?
She's an internal medicine doctor. She's the chief of staff at UCLA, I believe.
Okay, so, got it, so she's been practicing for 28 years. Good, that's what I wanted to know, because I didn't see that written elsewhere. I don't have any further questions, thank you.
Any questions on this side? Okay.
Actually, it's more of a comment. I think that, unfortunately, the doctor puts himself at a significant disadvantage by not being here, because I'd like to ask him the questions that you can't possibly answer. And that's my comment.
Thank you.
Any further questions from the board? No?
No?
All right. With that, the matter is submitted. The board will provide the decision in writing at some later time. And with that, matter is submitted and the record is closed. If you'd like to wait for a second, I'll get you a copy of the court reporter form.
Thank you, Your Honor. Thank you, members of the board.
We're now going into
Closed session. All right. I will open the record in the oral argument in the matter of the statement of issues against Ashani Naranya Carew. Is that correct?
Yes.
Okay. And this bears case number 8002016027529. This bears Office of Administrative Hearings number 2018-090553. My name is Deborah Nye Perkins. I am an administrative law judge with the State of California's Office of Administrative Hearings, and I've been assigned to sit today with the Medical Board of California, which is here in Quorum. I'll ask them to introduce themselves one by one, beginning on to my left.
David Warmoth.
Dr. Ron Lewis.
Jamie Wright.
Dr. Randy Hawkins.
Okay, thank you all. And I'd like to have the attorneys introduce themselves, please, beginning with the Deputy Attorney General.
Good morning, Your Honor, members of the board. Deputy Attorney General Brian Bill on behalf of the complainant.
Good morning, Your Honor, and board members. I'm Peter Osinoff, and I have the privilege of representing the applicant in this case, Ashani Carew.
And Ms. Carew is sitting next to you, is that correct?
She is sitting to my left, correct.
Okay, great. Now, I want to give you some rules. I'm sure you're probably very well aware of the rules with regard to how this proceeding will go forward. As you know, these are essentially arguments based on the existing record, so no new evidence will be heard today. And also, the panel members, including myself, may ask questions of the parties. However, they're not allowed to ask questions that would elicit new evidence. In addition to that, there are some time limitations with regards to the argument. First, respondents' counsel will be allowed to present argument for 15 minutes, and then the Deputy Attorney General may respond for another 15 minutes. Then Ms. Carew's counsel will get an additional 5 minutes to rebut, and then finally the Deputy Attorney General will get 5 minutes after that. Once the argument's finished, we'll open it up to the panel for questions. Having said that, Mr. Asanoff, would you like to reserve any time for your client to testify as well?
I was just going to ask that. Your
Okay.
Honor. My client has actually prepared a statement of her own. Ordinarily, the panel wants to hear from the client, and often they never get to hear from the client. But in this case, I felt it was important for this panel to hear directly from my client, Ms. Carew. The question that I have is, I would not want to have what usually occurs at the end and of being asked whether she wants to make a statement, take away from my time at the beginning, but I am happy to have her proceed at the beginning if it doesn't take away from my time. In other words, if we want,
Well,
if the panel would like to hear from her,
I understand.
I am happy to have that.
And I'm not sure how much time we're talking about here with regard to the statement.
I would estimate 5 minutes.
Okay, 5 minutes. In that case, would you like for her to provide the 5-minute statement before you begin, or would you like to have?
That would be fine, Your Honor.
Okay, and so, but let's, if everyone is agreeable to that, Deputy Mr. Bill, are you agreeable to allowing a 5-minute statement? I think typically what we do, however, is we do subtract that from your 15-minute argument time. If she wants to do that, I mean, you will have 15 minutes, 5, and 5. Typically, when you have the statement, we do subtract that from the actual argument time if you want to do that.
Well, what I was saying, if ordinarily in this case, the applicant is asked whether she has anything to say to the board,
Right.
And that is not taken out of the council's
Okay.
time
Mr. Bill,
ordinarily.
do you have any objections to that? What is your position?
Well, I would object to the introduction of any new evidence. I think
Right.
if respondent or applicant would like to discuss generally why she would like a license, I think
You have
that
no
would be
issues
fine.
with that. Okay, in that case, we'll allow the 5 minutes, as long as there's
Thank
nothing
you,
new
Your
that's going to be introduced, and then we'll go with the arguments.
That is fine, Your Honor, and I appreciate that. And I think her statement, as I understand it, would involve her description of her background and what she's been through, which I think is important
Okay.
for the panel to hear. And
Okay.
I appreciate that, and I won't try to
All right.
tread over that territory.
All right, in that case,
Thank you.
Ms. Carew, I'm going to place you under oath. Could you please raise your right hand? Do you swear under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth today in this hearing? Okay. And I note that you're probably going to be reading, and I'm going to ask you, note we do have a court reporter here, so if you could try to speak up with your statement and try not to go too fast because it makes it very challenging for him, okay? Okay, go ahead. Okay.
Hello, my name is Ashani Carew, and I would like to tell you a little bit about myself. I have always been a stellar student who earned honors on the Dean's List for 3 years at Pomona College, while also qualifying as a finalist for the Rhodes Scholarship. From the time I first set foot in a hospital as a volunteer, I have always wanted to be a doctor in order to help people. Unfortunately, after a brutal sexual assault in 1997, when I was still in college, I developed 2 anxiety disorders, obsessive compulsive disorder, and post-traumatic stress disorder. I became acutely symptomatic in medical school and had difficulties there until I got my disorders diagnosed and treated by Dr. Hendrickson, my psychiatry professor. While in medical school, Dr. Hendrickson helped me to get accommodations for USMLE Steps 1 and 2 because I could not function at full capacity, secondary to anxiety. I struggled through medical school, suffering an exacerbation of PTSD after the trauma of a car accident in which my car was totaled, although I had relatively minor physical injuries. Despite all my difficulties with anxiety, and despite the unexpected death of my mentor, Dr. Hendrickson, I successfully graduated from Creighton School of Medicine in 2004 with honors in psychopharmacology and research in psychiatry. Subsequently, I started residency at Cooper. While at Cooper, I was far away from family and friends and unable to find a psychiatrist outside of the residency program. As a result, I could not manage my anxiety and depression, which led me to have difficulty completing my residency at Cooper. However, I did pass a 6-month evaluation satisfactorily at Cooper. I did complete a full year of residency satisfactorily at Maricopa Medical Center. However, the trauma of being mugged re-triggered my PTSD, causing me to experience difficulties at Maricopa as well. After leaving Maricopa, with the help of a psychiatrist, Dr. Novak, I managed to get better control of my anxiety. By 2008, I was able to pass USMLE Step 3 without accommodation. I have worked hard to be a productive member of society, despite being unable to fulfill my lifelong dream of practicing medicine until today. Since 2010, I have obtained a master's in health administration with a 3.97 GPA from the University of Laverne, a Lean Six Sigma Green Belt certification from USC Marshall School of Business, which is a technique applying efficient industrial lean processes to healthcare. I have obtained a negotiation certification from Werner School of Law at Creighton and have held several high-stress jobs. While at Kindred Hospital, I oversaw the entire hospital at night and remained professional and competent despite the personal stressor of my grandfather dying from esophageal cancer. At Arrowhead Regional Medical Center, as healthcare program administrator last year, I helped the hospital obtain Joint Commission accreditation after 17 years and also helped them to obtain stroke accreditation and was responsible for handling unannounced surveys. While working for Supervisor Hagman in San Bernardino County, I have launched a health fair to help promote prevention of heart disease and have formulated the policy for use of telemedicine in the county. Despite holding stressful jobs, I have not required any leave due to stress or psychiatric conditions for more than 10 years. I have volunteered countless hours at the Bethel Community Food Bank, making care packages for the homeless. I found my work at the food bank very rewarding, and I hope to help the poor and underserved. In fact, my heart is set on helping the poor and underserved, and when I have my license, I hope to work in a community clinic to help the poor and underserved. Despite the hardships I have suffered in my life and the ensuing disabilities, I have worked very hard to overcome these conditions and have met all the requirements of the Medical Board of California for licensure. At the request of the licensing division, I have passed the physician competency assessment program at PACE. I have been clinically stable and symptom-free for the past 7 years, as my treating psychiatrist, Dr. Novak, attested to at hearing. I have gained additional skills in managing my anxiety through meditation and breathing classes. Indeed, Dr. McDonald, the board-appointed expert at PACE, agreed with Dr. Novak's assessment and found me psychiatrically fit for duty. I should not have further roadblocks put in my way for having the misfortune of developing anxiety disorders from a sexual assault 2 decades ago, exacerbated by other traumas that occurred during my medical school and residency programs, and in the case of residencies, rendered me unable to complete them. I was disabled in the past, but I have worked hard and have for many years now successfully overcome the difficulties that my psychiatric disability caused. Given all that I have been through, I humbly implore you to issue me an unrestricted license. To do otherwise would be a travesty of justice, particularly because the group of community clinics in our area, Park Tree Clinic,
I'm gonna object
does
to
not
that.
accept doctors on probation,
Hold on a second.
limiting
Hold on a
my
second.
ability.
Stop. Sorry.
That was beyond the scope of what was presented at hearing. That is new evidence.
Okay.
would
Your
ask the court to
objection
strike
is
that.
well noted, and I also note that we're also over the 5-minute time as well. Okay?
Thank you.
All right. So, Mr. Asanoff, if you'd like to start your 15 minutes of argument.
Thank you, Vice President. The board is aware of the difficulties of finding a job and getting on panels of healthcare plans, HMOs, hospitals, and clinics while on probation. Unless probation is needed to protect the public, there is no reason to make it difficult for a licensee, thank you very much, for a licensee to obtain employment. In any case, facing this panel, the panel asks, is there cause to impose what amounts here to discipline, and is probation needed to protect the public. The proposed decision, which was previously adopted by this panel, properly concluded that there was no basis for discipline, nor any basis for probation, no need to protect the public from Ms. Carew. In this case, there are three questions to be answered. The first question is whether Ms. Carew meets the minimum qualifications for licensure. The second two were raised by the Division of Licensing, and they are whether Ms. Carew is psychologically fit to practice, and lastly, is Ms. Carew competent to practice? All three questions must be answered affirmatively in this case. Ms. Carew meets the minimum qualifications for licensure. She graduated from an American medical school. She completed a year of residency, which included at least 4 months of internal medicine. In fact, she did very well during her first year of residency at Maricopa. It was not until she was mugged at the beginning of her second year of residency in July of 2007, which exacerbated her PTSD, that she could no longer continue with the residency. She passed all 3 steps of the U.S. MLE, and as she said, she didn't require any special accommodation by the time she took step 3 in 2008. The board previously denied her 2010 application for licensure based on a psychiatric evaluation by Dr. Shipko. 5 years later, Dr. McDonald at the PACE program disagreed with Dr. Shipko's conclusions, discussed them at quite some length in the reports that are in evidence, and agreed with Ms. Carew's psychiatrist, Dr. Novak. Dr. Shipko was incorrect in his conclusions reached in the 2010 application. Ms. Carew didn't request a hearing on the denial of her 2010 application, relying on the advice of a board's analyst, the written advice of a board's analyst, that she could reapply after 1 year. When she reapplied, however, she was advised by the licensing division that the advice she had received was incorrect and that she had to wait 3 years. She applied again in 2014. At that time, the board agreed to extend the time for the validity of her USMLE scores, provided she passed a clinical evaluation. She also updated the application in 2016. So she went through a very expensive PACE program, which included not only the clinical competence evaluation, but the fitness for duty evaluation as well. She underwent multiple standardized evaluations in Phase 1 in October 2015, along with a psychiatric fitness for duty evaluation by Dr. Kai McDonald. The microcog evaluation, which this panel is familiar with, is taken on computer and revealed unexpectedly slow processing by Ms. Carew, which may have been a computer issue since she was thereafter sent for neuropsychological testing, which she successfully completed before she took Phase 2 in early June 2016. Dr. McDonald agreed with Ms. Carew and her psychiatrist, Dr. Novak. She had worked hard on her issues of PTSD and severe anxiety, OCD, that resulted from her sexual trauma 20 years ago and were exacerbated by the incidents in medical school and residency. He noted that it's easy to say on first blush that she isn't fit for duty based on her history. However, he concluded otherwise, finding her psychologically fit for duty as a physician. While she had some physical tremors and autonomic manifestations of anxiety, her attitude was friendly and professional, and she was able to control her anxiety. There was no evidence of any cognitive issue, nor of any slow reactions, and there was no hyperactivity. Dr. McDonald found that 5 years of new behavior patterns since 2010, which she had achieved through continued work with her psychiatrist, Dr. Novak, is plenty long enough to establish that her disability doesn't present a risk to herself or others in the work environment. She has worked in stressful situations since then and has done so professionally and without absences. Her supervisors and colleagues testified on her behalf at the hearing regarding her ability to work well under pressure, to work with other people, even to mediate between physicians and nurses, and regarding her integrity and honesty. If 5 years of such changed behavior was sufficient for Dr. McDonald, surely 8 years is sufficient for this board to conclude that she's fit to practice. Dr. McDonald noted significant improvement in her insight. He found that it was safe and reasonable to allow her to treat patients. He addressed Dr. Shipko's report in particular, upon which the earlier denial of her application was based, and upon which the present position of the Attorney General's office is based. Contrary to Dr. Shipko and the Attorney General's position, Dr. McDonald found that Ms. Carew's behavior 15 years ago and during her residencies did not show a pattern, during her medical school and residencies, did not show a pattern of compulsive or pathological lying, which is what the basis of much of the statement of issues is about. Instead, her behavior fit, according to Dr. McDonald, a pattern of attempting to save face. As Dr. McDonald said, her behavior must be understood in the context of the psychological concept of shame. All the issues of dishonesty, according to Dr. McDonald, years ago, involved situations in which she would lose face or have to reveal something about herself that wasn't socially as acceptable. Dr. McDonald found that she had worked through these issues of shame just as she had worked through her PTSD, and that she no longer engages in such conduct. In fact, he found she was quite forthcoming and direct, as I'm sure you have found today. Dr. McDonald went on to say, perhaps in fairness to Dr. Shipko, that Dr. Shipko didn't have accurate information about the extent of verbal and emotional abuse that Ms. Carew had endured in her earlier years. Dr. McDonald found no evidence of any personality disorders, such as compulsive lying, which would have become manifest over the course of Dr. Novak's years of treatment. There is simply no psychological disorder that presents any risk to patients. And there is no dishonesty in Ms. Carew's applications to the board, not in 2010, nor the 2014, nor the updated application in 2016. I would challenge this panel of the board to find another application with as much disclosure as in Ms. Carew's applications. You can take a look at her applications and what she has written in that. Did she write a dissertation? No. But did she disclose everything? Yes. And further, she provided releases for her medical school and residency programs to provide full information and documentation to the licensing division. In fact, she provided at least as much information as her residency directors, and even more. She disclosed her absences and her history of mental illness. She disclosed that she had been placed on probation at Cooper, while the director of that program didn't even disclose her probation. The ALJ found that she wasn't dishonest at all and had no intent to hide information or any details from the board. The recommendations made by Dr. McDonald were made at a time during the evaluation when she had advised that she wanted to go into the field of psychiatry. These were recommendations regarding the nature of her practice. If she went into psychiatry, how they would need to supervise her in that practice. They weren't clinically needed unless she practiced psychiatry dealing with difficult patients. His recommendations were not made with the view that the board would impose them upon her during a period of probation. The board cannot put a license on probation for conduct that was the product of a disabling condition that has clearly been overcome for 8 years now. As to her competence to practice, she did well on phase 1 of Dr. Schulman's family medicine oral clinical evaluation, which involved multiple complex scenarios. He noted that she did quite well and scored in the high average range. She didn't do well at all in her exams for psychiatry, not surprisingly, since she only had 1 year of a psychiatric residency with half the year spent in internal medicine. And by the time she returned for phase 2 in early June 2016, she had given up her plan to have a psychiatric practice, and instead she announced her goal to be a general practitioner. In phase 2 evaluation for general medicine, Dr. Schulman, along with Dr. Bazo, conducted a standardized patient evaluation in which she scored in the high average range. Not surprisingly, PACE found that she needed more practice to become proficient in her physical examinations, but remarkably important is the fact that her clinical judgment was found to be very good. She received satisfactory to superior scores on all categories of training. The 3 evaluators who knew she hadn't completed her residency concluded that she needed further training or supervision in her practice. The 4th evaluator, who apparently wasn't aware of what brought her to PACE because he was busy the night before and came late, had no major concerns when he evaluated her clinical competence and didn't recommend further training or supervision. Since no major deficiencies were identified, one can only conclude that the other 3 evaluators were influenced in their recommendation by the reasons that the board referred her to PACE. The fact that she hadn't practiced in recent years through no fault of hers, and the fact that she hadn't completed a residency program. If you take away the bias of knowing her history, she was clearly adjudged to be clinically competent. There would be no recommendation or reason for her to complete a residency training or to have a supervised practice. In this case in particular, with her background of disability, bias should play no role whatsoever. Now, in fact, that's exactly what ALJ Reyes, who heard this case for 2 days, concluded at page 15 of his proposed decision, previously adopted by this panel. As he says, the reservations expressed in the final PACE report were not based on an analysis of respondents' clinical competence or on observations of her performance, but rather stem from concerns about the time she has been absent from the practice of medicine and about her mental health. Well, after all, that was the reason why she went through the PACE program, to be evaluated in her competence and mental health. Her performance in the PACE program, the process through which her competency was thoroughly assessed, demonstrated her clinical ability to safely practice medicine despite her absence from active practice. So says Judge Reyes. Now, any clinical concerns which would require monitoring are removed as long as Dr. Carew doesn't practice psychiatry. The training requirement in psychiatry proposed contingently by the administrative law judge is based upon her testing in that field and is only a contingent requirement. The same would be true for any licensee who hasn't had a recent residency in psychiatry. This board would not restrict their practices if they didn't go into a specialty that they hadn't fully trained in, and Ms. Carew will not. There is no reason to license Ms. Carew and then stop her in her tracks with probation, directing her to practice in a group where she can be supervised as if she could ever find group practice while on probation. In fact, she doesn't want to open up her own practice. She wants to work, as you heard, in a community health clinic, which is a good environment for her, also suggested by Dr. McDonald as a good environment for her, and there is no reason to impose any psychiatric care when for 10 years she's been under the care of a psychiatrist and intends to continue in that care. She welcomes additional CME, and there's no reason to mandate further CME where she's shown no deficient patient care. This is not one of those cases where there's any deficiencies in care. And as found by ALJ Reyes, she didn't engage in any unprofessional or dishonest conduct. The proposed decision, previously adopted by this panel, is the well-reasoned product of one of the most respected ALJs in this state. You should adopt it once again and not drag this licensure process out any further. Thank you very much.
24 seconds left. Okay. All right, Mr. Phil, would you like to respond?
Yes, thank you. The issue for the board to decide today is whether a person who is deemed to be unsafe to practice independently by PACE and who has had a continuous issue with her veracity should be given a license to practice in the state of California. And based upon the facts that presented at hearing, it's clear that respondent has proven that she is not competent to practice without substantial supervision, and that she had lied to the board in her applications. She lied to the Medical Board of Arizona in her previous application, and she lied at hearing. In this case, an understanding of the law that's applicable, I think, is important for the board in making their decision. In a statement of issues cases, the burden of proof to prove license worthiness is placed solely on the applicant. Government Code Section 11504 states that a statement of issues shall be a written statement specifying the statutes and rules with which respondent must show, respondent must show compliance with by producing proof at the hearing. Government Code 11500 defines the respondent as any person against whom an accusation or against whom a statement of issues is filed. In addition to the statutory law, there are a whole host of case law that talk about the burden of proof in an application for licensure case being placed solely on the respondent's shoulders. Specifically, I would point the board to a case called Koningsberg, that's Konigsberg versus State Bar of California. And that's a U.S. Supreme Court case. That's 366 U.S. 36. Respondent, in their responsive brief, fails to accept the fact that the burden is solely placed on her. So the facts that were presented at hearing indicate that respondent is not competent to practice without substantial supervision. According to the PACE reviewers, and this is during the second portion of PACE where she was tested on general family medicine, during a clinical session evaluated by a Dr. Hatami, Dr. Hatami stated, this is a quote, "Overall, her performance needs improvement. I would recommend that she complete the uncompleted residency years or practice under supervision for at least 1 year before she's ready to practice independently." In another clinical session evaluated by Dr. Ginn, Dr. Ginn states that Dr. Carew's medical knowledge was appropriate to her level of training, but since she's not trained in family medicine, she has not had the exposure to the breadth and depth of family medicine. And finally, Dr. Gutierrez stated, quote, "I am concerned about her ability to practice independently given her limited training and lack of formal clinical experience. Her knowledge base seems adequate for the conditions presented today, but the clinical experience was very limited. During the session, we had no pediatrics presented, no cardiac, no pulmonary, liver, chronic pain, or gynecological issues, and no orthopedic conditions." In the PACE summary, the conclusion was that 3 out of 4 evaluators commented that they were concerned with her level of training and stated that she would need further supervision if she returned to practice. Further, based upon phase 1 and 2, the PACE reviewers did not feel that she was safe for independent practice at this time. As a result of her time at PACE, she was issued a pass with category 3, and that is defined as a pass with recommendations. Specifically, category 3 is defined as, and this is a quote, significant deficiencies were noted. The physician is capable of practicing safely, but may not be reaching his or her full potential. Physicians in this category are likely to have broad deficiencies that cover multiple domains and will require considerable educational investment and occasionally a change in behavior. And then recommendations to remediate the issues followed. In this case, it is clear that the PACE reviewers were exceedingly concerned about her ability to practice independently. And as a result of her performance, they issued a number of recommendations that included substantial oversight. I would like to point out to the board that in her brief to the board, respondent misstated the facts regarding the PACE review. Specifically, respondent argued that, and this is a quote, "The PACE definition of Category 3 expressly states that the physician is capable of practicing safely, period." That was an attempt to mislead the board regarding the true definition of the PACE passing category. I think based on the PACE review, it's clear that respondent lacks the ability to practice independently. And if the board is going to grant a license, that license should contain a term of probation with substantial oversight required. And if that were the only issue presented in this case, then that probably would be a reasonable outcome. However, in this case, there's a history of veracity, a lack of veracity on the part of respondent. And this has been documented beginning with her time at Creighton Medical School, and it persisted through her failed residencies at Cooper and Maricopa. It persisted through her applications to the Arizona Medical Board, with her applications to the California Medical Board, and during her testimony at hearing. I'd just like to point out a few of the lies that were presented. First, respondent in her application to the board indicated or stated that she took a second leave of absence from Creighton Medical School as a result of injuries she sustained in a motor vehicle accident. The only interpretation of that statement is that she was physically injured. At hearing, we then later find out that she did not suffer physical injury. Rather, her injury was psychological in nature. However, that information was not specifically stated in the board's application. Additionally, respondent provided false statements regarding her third leave of absence from Creighton Medical School. Respondent describes that leave as as Creighton misinterpretation of their own policy. And I would submit to you that this is editorializing at best, but blatantly false at worst. This third leave of absence resulted from her failure of a second course. She was ultimately terminated from the school. That is the reason for the third leave of absence. Respondent also provided false statements to Maricopa regarding her failed residency at Cooper. She failed to disclose that she attended Cooper at all. She also failed to disclose that information to the Arizona Medical Board. At hearing, respondent attempted to explain away her failure to disclose that evidence to Maricopa as well as the medical board. She stated that she misinterpreted the confidentiality agreement set forth by Cooper. However, upon her release from Cooper, she was provided a letter, to whom it may concern letter, that described her time at Cooper. And that letter was intended to be given to future residency programs. So she very well knew that she could disclose that information, that she attended Cooper to Maricopa. Moreover, she knew that she was under the obligation to disclose that information to the Arizona Medical Board when she applied for a temporary license. At hearing, respondent attempted to downplay her lies to the Medical Board of Arizona. She testified that Maricopa did not consider those lies to the board as a main reason for her dismissal. Once again, this is false. The Maricopa staff drafted a memo that specifically stated as the number one reason her failure to disclose her time at Cooper to both Maricopa as well as the Arizona Medical Board. So once again, respondent argued today that her lying is under control, that she has not exhibited any of these symptoms in 10 years, and that's just simply not true. She began lying in medical school, and she's still doing it today. Whether it's caused by a mental health condition or something else, I would submit to you that is irrelevant. So we're not concerned with the cause of it, rather we're concerned with the actual behavior. And if she's still doing the behavior, that's the only thing that the board should consider. I will agree with respondent in one regard. She has had a difficult journey, and it hasn't always been her fault, and I will agree with her. And I think that it's a normal thing to want to help a person in her position. It's normal to want to, it would be normal to want to give her a free and clear license for someone who's worked this hard and has waited a long period of time. And if I had to guess, I would say that Judge Reyes felt this way when he drafted his proposed decision. And I think it's clear that he did feel this way because, as stated in my brief to the board, there was numerous instances where he left out applicable and relevant facts that speak directly to respondent's incompetence and her veracity. And so I would imagine that when you discuss this case after we're done talking, that you'll probably feel this way yourself. You probably will feel this dissonance. So I think the best way of dealing with that is, one, to acknowledge it, but two, to ask yourself, would I seek treatment from a physician who is deemed to be unsafe to practice without supervision? Would I refer to a loved one to a physician who lied to a medical board? Would I refer a family member to a physician who was essentially terminated from both her residencies? Would I refer a friend to a physician who has a history of lying by omission? Would I send my child to a physician that was dishonest in her applications with the medical board? And if the answer to any of those questions is no, then I would submit to you that you must deny the application. If the answer to those questions is no, then it's clear that respondent has not met her burden of proof and that she has not presented you with sufficient evidence to warrant licensure. But I'll take this a step further. If the answer is, I don't think I would send my child to a physician like this, I probably wouldn't send a friend to such a physician. If there's any equivocation in your analysis, then I would submit to you that respondent has not met her burden of proof. This is not I believe that based on the facts that were presented at hearing, respondent has not proven that she is license worthy. And the people of the state of California should not bear the risk of a physician who has been deemed to not be competent to practice independently.
15 minutes, go.
And who's had serious ongoing veracity issues. I would ask that the board deny respondent's application request. Thank you.
Okay, Mr. Astanoff, you have 5 minutes of rebuttal.
Thank you. I would ask this panel, would you send any family member or friend to anyone who has just been licensed by this board with 1 year of residency? Probably not. Probably not. You'd want them to have more experience. You'd want them to have more dealings with colleagues. But we don't put those people on probation. We give them licenses if they've met the minimum qualifications. And the burden of proof is upon us to show those minimum qualifications, and that was shown. But the burden shifts then to the board if it claims there are reasons why, despite the minimum qualifications, Ms. Carew should not be licensed. There is no ongoing lying in this case. ALJ Reyes considered this for 2 days of hearing and found no ongoing lying. Most of that time was Ms. Carew's testimony, and then also the character witnesses and the testimony of her psychiatrist, Dr. Novak. If you look at the application, I think it was said that the reason given by Ms. Karani in her application as to why Creighton said she couldn't continue was because Creighton misinterpreted the policies of their handbook. That is true, but she also goes on to say, and said that I couldn't continue because I failed 2 rotations. Okay, so she discloses a lot in here. She discloses that when she went to medical school, the first leave was when she attended a cognitive behavioral therapy at UCLA. And I might add, when she talks about medical leaves of absences in this and goes at great length in her explanations, typewritten explanations taking up entire pages, that is very impressive. When she goes into these explanations, she does talk about her medical leaves, her return home to California and seeing a psychiatrist who diagnosed her as being depressed. The office visits with a psychiatrist made her feel better, but then she talks about being placed on probation at Cooper. She discusses Cooper for 3 months at probation, and she thoroughly talks about the Cooper residency in her applications to the Medical Board of California and in her testimony at the hearing. The reason she did not talk about this, and by the way, the letter reference was never in evidence, the letter that was given by, supposedly by Cooper. I've never seen that in any of the evidence in the case. But be that as it may, the confidential agreement was a strict confidential agreement that she couldn't reveal anything about her attendance at Cooper. Nothing about her being at Cooper can be disclosed as according to the settlement agreement. And she thought that should be strictly interpreted and didn't disclose that to Maricopa or to the Arizona board at the time. We're talking 11 years ago now. As far as that is concerned, not even Cooper disclosed when Maricopa did an investigation. When that became apparent, Maricopa did an investigation, and Cooper wouldn't disclose anything about her attendance or any information to Maricopa, because even Cooper thought that confidential agreement was to be treated confidentially. She has since then, however, with the Medical Board of California, thoroughly disclosed everything about Cooper. And so her history of lack of veracity is not a pathological matter. It was totally analyzed by both Dr. McDonald, Dr. Novak, and the ALJ Reyes. And this is not an issue that is continuing. Any minor details that may be left out of an application are not significant. Medical injuries does include, by definition, under the ADA and everywhere else, includes psychological injuries. So she did disclose that. As far as the Category 3, Category 3 is capable of practicing safely, but those physicians are likely to have significant deficiencies. No significant deficiencies were found by the testing done by Dr. Schulman, the family practitioner down there, and no significant deficiencies specifically in the conclusion of PACE. There were no significant deficiencies found by the PACE program. And this was analyzed and read thoroughly by the ALJ. The deficiencies were in the area if she wanted to go into psychiatry. Then there would be deficiencies, and she will not go into the area of psychiatry any more than someone would enter the area of neurosurgery, cardiology, or any others without practice. 1 minute?
We've hit the 5 minutes.
Anyway, So thank you very much for your attention.
Okay, Mr. Bill, you get the last 5 minutes rebuttal.
Thank you. Once again, I would disagree with respondents' legal analysis regarding the burden of proof, but assuming that respondents' analysis is correct, which I don't believe it is, but if the burden did, for some reason, shift to complainant to show that respondent was incompetent and lacked veracity, I think I certainly have done that. The PACE report clearly indicates that after her time at phase 2, where the supervising physicians reviewed her clinical ability with respect to family medicine, 3 out of the 4 concluded that she should not practice by herself. Don't know how much clearer that is to show that she's not capable of practicing independently. Similarly with the veracity issues, I discussed at length in my filings with the board the numerous instances where she editorialized and lied by omission at every step, from medical school to Cooper to Maricopa to the Arizona Medical Board to her board application here to her hearing testimony, and then today. Today, if you heard respondent discuss her failed residencies at Cooper and Maricopa, she framed it as rather than taking responsibility for failing at those institutions, she simply glossed over it and said that she no longer could continue. And I think that editorializing is fine if you're a journalist, but if you're applying for a license, a professional license where veracity is really a cornerstone of the profession, editorializing is not something that should be done. And I would ask you, do you want to go to a physician? Would you seek treatment from a physician who editorializes their medical records? I think that the answer is no. I think in this case, respondent hasn't shown that she has this extended period of time of being truthful and honest. And she hasn't shown that she is competent to practice independently. And for those reasons, I would ask that you deny her license, deny her application. She needs more time to think about why she feels the need to editorialize, why she feels the need to fail to present the full and complete information. She needs to present this information to the board before the board should grant her a license. Thank you.
Okay, with that, we're going to open it up to questions from the board. Do we have any questions from anyone on the panel to my left? One? Go ahead.
What's the plan if you're going to get a license? Restrict or unrestricted?
Sure. As I mentioned, my lifelong dream is to help the poor and underserved, so I would like to work in the group of community clinics in locally, Park Tree clinics, but unfortunately they don't accept doctors on probation, so I...
Along with that line of questioning, what field of medicine do you plan to practice or desire to practice?
I plan to practice only family medicine and absolutely no psychiatry. If I ran across a patient who had a psychiatric condition, I would refer them out after conducting a general medical panel to rule out any general medical conditions which can present with psychiatric symptoms.
Are you aware that if you have a unrestricted license, you could practice almost anything, including psychiatry? So when I look at the comments from, I think, PACE 1 and 2, there were some concerns about further development of your knowledge base in psychiatry, if I'm not mistaken. correct?
Yes, that is
Okay.
correct.
So, how do you plan? See, we have to protect the public. That's our primary goal, right? So if you get an unrestricted license, you could go out and practice, almost anything if you had privileges to do so. So when we see those concerns of the PACE faculty, we have to kind of figure out, okay, how can we protect the public? Because you could tomorrow open up and say your shingles and say, I'm a psychiatrist.
Right. Thank you for raising that issue. Actually, I think the concern you raise is appropriate. However, you would have to take my word that I would not practice psychiatry the same way I would not practice neurosurgery or practice pediatrics. I plan to practice adult family medicine. In the case of other applicants who have possibly received an unrestricted license, I believe that you would be taking them at their word that they would not practice outside of their field of expertise. So I'm asking you to grant me that same courtesy.
The last time you practiced medicine hands-on with a patient was when?
Is that excluding PACE, sir?
Excluding PACE, because PACE is more of a controlled environment. I'm talking about in a residency, in a clinic.
In a residency.
Yeah.
In a residency, it would have been 2008, just prior to the mugging. Was it
Okay, so-
I'm sorry, 2007.
2007 is the last time you had hands-on, outside of PACE, interaction with a patient.
Hands-on
That was
interaction with the.
during- What was that, during a residency or?
That was during my residency at Maricopa Medical Center. I have worked in a hospital setting, but not practiced direct patient care since that time. I have worked in healthcare administration, so I have dealt with clinical issues, but not hands-on direct patient care.
Okay, I think the rest is in the record, which I've read, so I don't have any further questions. Thank you for
Okay.
your response.
For 1 second, that last
Yeah.
question, and that's precisely why it was that concern that led the Division of Licensing to, along with the history of psychiatric illness, that led which was disclosed by the applicant, of course. That led them to say, if you want us to extend the USMLE scores, you have to go and take the PACE program and pass that. And that was why that was the requirement, a precondition to be licensed. So that's why they had her do that, just to see if she was competent. And the rest of we have argued at length as to the results of the PACE program. Thank you.
Any questions over here? No? No questions? Any further questions? All right, so if there's no further questions, with that, the matter is submitted. As you know, the board will send its decision in writing at a later time. So with that, the matter is submitted and the record is closed. If you'd like to wait for a moment, I'll get you a copy of the court reporter form, and then we will go into closed session.